Judicial Council to order. David, call the roll.
Chief Justice Nathan Heck here. Presiding Judge Sharon Keller. Carlos Amaral. Judge Gary Belair.
Here.
Justice Bill Boyce.
Here.
Ms. Sonia Clayton.
She just stepped out. Okay.
Senator Brandon Creighton. Judge Bill Gravel. Ms. Allison Ho. Judge Scott Jenkins.
Here.
Ms. Ashley Johnson.
Here on the phone.
Judge Kelly Moore.
Here.
Representative Andy Murr.
Here.
Judge Valencia Nash.
Present.
Chief Justice Sherry Raddick.
Here.
Mr. Ken Sachs.
Here.
Representative John Smithy.
Here.
Judge Polly Spencer. Judge Ed Spillane.
Here.
Judge Vivian Torres.
Here.
Mr. Evan Young.
Here.
Senator Judah Saffarini.
Present.
Welcome, everyone. It's cold, damp February morning. We'll hear from our committees today and a number of reports about various different items, and we have a couple of action items to look at. The Centers for Excellence program approval and the change in the CIP rule, the collection improvement rules for fines and fees. You had an opportunity to see the minutes of the September meeting. Are there any corrections or suggestions? All in favor? Aye. Minutes are approved. We'll move to the report from the Texas Indigent Defense Commission. Presiding Judge Keller can't be here this morning, but I still think of him as new. Executive Director Jeff Burkhart will give the report. Jeff?
Thank you. Morning, everyone. So I am the new director for the Texas Indigent Defense Commission, as some people call me, the new Jim Bethke. I'm happy to be here. I was asked to say just a couple words about my background. Most of my work has been in criminal justice. I clerked for an appellate court judge, I worked at a law firm, but the bulk of my time was spent in a public defender office, where I handled anything from misdemeanors to murder cases. And most recently worked at the American Bar Association, where I first staffed the Standing Committee on Legal Aid and Indigent Defendants, which is the oldest standing committee at the ABA. It's actually going to be 100 next year. And it's focused largely on civil legal aid on one hand and public defense or indigent defense on the other. And I was really kind of the public defender guy at the ABA for a few years. Most recently, I worked at the ABA Center for Innovation as the deputy director before coming down here. I was fortunate before coming down here to actually work with Jim Bethke, to work with Alex Bunnan, to work with Dottie Carmichael. So I had a lot of exposure to TIDC, and I'm proud to say whenever another state came to me and they said they were starting a new commission and they asked where they should start, I always sent them to TIDC. So this really is kind of the cream of the crop in terms of these sorts of commissions in the United States. So I'm very happy to be here. Briefly, what we've been up to. So really, I've had a couple priorities at TIDC. The first one is really to maintain the great work that TIDC has been doing for years. So under the leadership of our chair, Judge Keller, and my predecessor, Jim Bethke, we have done a lot over the past 16 years. The second priority is to really look at more innovative things. What can we do to expand and to improve? What can we do to make indigent defense more efficient, more effective, more fiscally responsible? So first I'll talk about that first priority, what we've been doing for a long time and how we're maintaining that, or how we're maintaining that at TIDC, and then I'll talk about just a few of the innovative things that we're working on. First, with our grants, we're in the process of sending out all of our formula grants to Texas counties, and we just opened up our solicitation period for discretionary grants. So formula grants are on their way out the door. Discretionary grant solicitation period is open, and we've actually had a lot of interest. We just recently held a webinar about that. Monitoring, which we do both fiscal monitoring and policy monitoring. We just set the year's schedule for monitoring. And we have policy monitors out in the field this past week, fiscal monitors out in the field next week. So we've got a pretty rigorous schedule as far as that. Publishing, we have a lot of stuff going on. Most recently we published, this is the most recent edition of the Fair Defense Laws, and I believe Scott Ehlers from our office has a few copies with him if anybody wants a copy of it. In addition to that, we just published the Managed Assigned Counsel Programs and Operation. So there were really, when you're talking about indigent defense, really just a few options in terms of the ways to provide it. Public defender offices, managed assigned counsel systems, contract systems. And this really is a guide that we've been working on for quite a while. And actually, Scott's really the main author and the one that we have to thank for this. This is an electronic guide, so this is primarily just on the internet. But in this, Scott and TIDC really explore how managed assigned counsel systems actually operate on the ground. And he looks at 3 different systems here in Texas, as well as several systems outside of Texas. So this is a great report. And as far as events, back in November, we had our 2nd annual mental health roundtable, and we hope to have another one this coming November. We had a great turnout. We had about 50 attendees. We worked with several other Texas agencies, including HHSC. So great turnout for that, and a big focus for, of course, TIDC as well as OCA and others has been mental health recently, so we're very proud to be a part of that movement. We also recently had a training down in Brush Country in Eagle Pass. We're talking to folks in Big Bend to work on another training down there. And we're right now planning our strategic planning sessions, which should take place in June out in Kerrville. Now, getting back to the innovative approaches that we're working on, we have a few things kind of in the works. One, our staff is really looking at innovative approaches across the United States for indigent defense. A lot of it is we really just want to have our finger on the pulse of what's going on out there. What is actually effective? What's really new and what's really impressive in terms of effectiveness, efficiency. So we're researching that with an eye toward doing a publication. As I mentioned, the discretionary grant solicitation is open, so that would be the second thing in terms of innovation. We've been talking to a lot of people around Texas about both tech projects and non-tech projects that would really advance indigent defense in Texas. And then the last thing I'll mention in terms of what's going on at TIDC, we've been in discussions with IBM recently. And IBM has, as I think everybody knows, a very large engineering department. What a lot of people don't know is they have a very large design thinking department. And if you're not familiar with design thinking, essentially what we're talking about is creative approaches to problem solving. Anytime a human being is interacting with a system or a process, how do we improve that process? So the folks at IBM have very kindly offered to give pro bono services, pro bono training to our staff and to staff at OCA in order to really refine our processes. So that's a huge innovation and something I'm very excited about. The very last thing I want to mention before, and I'm happy to take questions after that, is we have a new member. And she is not new to the Texas Judicial Council, but she is new to us at TIDC, and we're very excited to have her, Judge Torres, and she's bringing a lot to TIDC, and we're very excited to have her there. And that's it for the update for TIDC. I'm happy to answer any questions you might have.
Questions for Jeff? Great report, Jeff. Thanks very much. Thanks for all the good work the commission does. We'll hear from Angela Garcia on the about to be released statistical report for the Judiciary for fiscal year 17.
Good morning, everybody. We'll start off with Class C cases. The number of Class C cases has continued to decline by about 3% overall from the last year. Traffic and parking cases are the lowest number since at least 1980. And non-traffic cases are the lowest since 1985. Declines occurred in every category except local traffic ordinance cases. The most significant decline for some reason was in parking. And although the state traffic law cases declined by only 3%, they make up of 80% of the Class C caseload. So any small decline there makes for a big impact in the filing list. The number of Class C cases involving juveniles or minors declined by 2% overall from the previous year, but it's declined by 58% over the last 5 years. Filings continued to decline in 2017, except for in the drug paraphernalia and tobacco categories. Changes to school ticketing and truancy laws led to an 80 to 90% decline in these categories over the last 5 years. But truancy and education category cases, case category may have bottomed out in 2016 because there have been increases in 2017. You can see truancy increased by 50%. The number of new Class A and B misdemeanor cases declined by 2% overall from the previous year, and fell to the lowest level since 1993. It's fallen 31% from the peak in 2007. Some case categories saw slight increases in 2017, while theft cases declined significantly. Over the last 5 years, the only categories that have consistent increases are the drug-related cases. And these cases make up 20% of the caseload, which is the largest category other than our all other misdemeanor category, which is a catch-all. The number of new felony cases increased slightly each of the last 5 years. Drug cases, which account for 1/3 of the caseload, increased at the greatest rate over that period. Felony drug possession has reached an all-time high. The number of new family cases increased by less than 0.5%, so basically remained steady compared to the previous year. But of particular note is the increase in the child protection and termination of parental rights cases. Child protection cases have increased 26% over the last 5 years. New civil cases continue to increase slightly in district and county courts, but they increased significantly in justice courts and declined significantly in municipal courts. In municipal courts, the civil cases are primarily parking. There are also red light camera violations, substandard building code violations, and nuisance abatements, and health and safety code violations. Civil filings increased in nearly every case category. In terms of the volume of cases, the largest increase in the district and county courts were in the debt cases, which account for 22% of the caseload. And the next largest increase came in the motor vehicle torts, which have continued to climb significantly. In justice courts, this is the most shocking trend, I think, of the annual report statistics. Debt collection cases soared by 46%. And I took a look at the statistics by county, and 83% of counties have reported an increase. All but one of the 50 largest counties have increased significantly, and those increases range from 19 to 100%. We've got a significant trend going on there. The number of new probate and guardianship filings decreased by 1%. The number of new adult guardianship cases declined by 11%, most likely due to the recent legislation and alternatives to guardianship. And the number of active guardianship cases reported declined, and that is due to OCA's Guardianship Compliance Project, which has gone through and reviewed all these case files for counties and recommended thousands of cases for closing. The number of new involuntary mental health commitments has continued to climb to an all-time high, almost 50,000 cases. And if you remember from previous years, this big spike is due to Dallas County finally deciding to report. So ignore the big increase. Overall, the filings in the 14 courts of appeals declined by 4%. Criminal cases went down 12%, but civil cases have increased by 4%, which follows the trial court trends where civil filings are increasing and criminal cases are decreasing. And up at the top, in the courts of criminal appeals, filings declined in all categories, which is consistent with the downturn in the criminal filings. And in the Supreme Court, filings have increased in all case categories, consistent with the increase in civil cases. And that's all I had. Any questions?
Yes.
Yes.
Angela, when you discussed felony cases,
Yes.
so you had the slide, and they're not numbered, but in that it talks about drug possession going to an all-time high. And I think the OCA reporting requirements, they don't actually require the clerk or anyone to identify the specific drug named. It's simply that charge. My curiosity is, are we able to identify, or could we take steps to maybe ferret out which drug or drugs is really driving the increase in caseload? Because commonly I see methamphetamine as probably the biggest driver, but I didn't know if that was actually in the data. And then you flip back over when we talk about misdemeanor cases and we want to talk about opioid use, that would probably fall into other drug offenses on the slide before this. And that shows a 5-year increase, but not really a big increase. And that's the possession of a dangerous drug. And that's another discussion we've had in the past. But I was curious if there are any recommendations how we would ferret out additional information.
Right now, we're not able to do that. You know, what you see is what you get on these
Sure.
case categories. The data committee is looking at changing data collection in the future to a case level data. So that would probably be offense level, and in the future, we would be able to ferret that out.
We might be able to, and Angela, maybe we can look at this for the next meeting, and especially for the Criminal Justice Committee who's specifically looking at this issue, but we might be able to look at DPS arrest data to get some of that information with regard to drug type. I'm not exactly sure, but we can try to dig into that and see what we can find, because I know I'm hearing the same thing that you're hearing, which is that it's maybe not opioids that are driving it, maybe other types of drugs that are driving that.
Well, and I know when the clerks go in and they have an information or an indictment, they can simply look at the face of that whenever that data is entered. But the list of defined substances is so long, I wouldn't want them to have to go in and choose that. They would just simply need to say, the indictment says this, and so I check this box in the reporting requirements. I'm just curious how difficult that would be going forward. Thank you very much.
Some states have what they regard as a crisis on opioid use. In the Northeast a lot, some in the Midwest, Atlantic states. But we don't seem to have a problem in Texas like other states.
Not to the same degree.
Yeah, we don't know what accounts for that. But.
And Chief, my observation would be it appears that methamphetamine use is higher, and I don't know, and I'm kind of looking for data, if that has to do with socioeconomic status in the community, so that those that have the ability to access, they're affording opioids, and then therefore they're not really ending up in our criminal justice system because those are typically treated as a misdemeanor. And then those that can afford it, it's more of a methamphetamine-driven data, and they're in our criminal justice system and in our jails, and that's part of what our discussion has had in the past on the Criminal Justice Committee. So this kind of data could help us get there a little closer.
We'll dig in.
Okay.
See what we can find.
Other questions for Angela? Yes.
I was wondering, the hot check collection was way down and the debt collection was way up. Is there a correlation there?
Well, the hot checks are because the law no longer exists.
Okay.
So they've dramatically gone down.
And I was wondering if it was because the hot checks were falling off because everybody's gone to debit cards that you can't.
Very well could be.
And that's why they're not paying their bill now.
Yeah, I think you're onto something there.
One of the things that the Civil Justice Committee is looking at, and specifically, I don't want to steal Chief Justice Raddick's thunder when she gives her report in a minute, but we spent a little bit of time last week with a group of folks looking at civil justice reform, and spent a lot of time on talking about debt collection issues, because it is exploding. It is a significant portion of the caseload on the civil side now, and there are a lot of things that are going on that at least judges and lawyers are concerned about with regard to the debt collection efforts and the way things are happening in our courts. So I think my guess is that the Civil Justice Committee will have some specific recommendations that address how debt collection cases are being handled. And I'll give you just one real quick specific example. When the Supreme Court worked with the justice courts to redo the rules for debt collection cases in the justice courts, they required that a copy of the contract or whatever document obligating the person to pay the debt be included with the petition, so that there was some proof that could at least be provided at the time of filing. That same thing doesn't apply at the higher, in the county courts at law or the district courts. And so the discussion that went on last week was, well, that's had a good impact in the justice courts, of at least the judges know that there is some contractual obligation that the person actually owns the debt that they're suing for. So anyway, those are top of things that I think the committee and some of the rest of the committee will be looking at and providing some recommendations for you all to consider on that at the next meeting.
All right, any other questions? Thanks, Angela. Always an interesting report. Last session, Chairman Smithy and Senator Zaffarini sponsored Senate Bill 42 in the legislature, the Judge Julie Kusurik Judicial and Courthouse Security Act, which OCA is in the process of implementing. One of the things that we have done is hired a security director, as called for in the statute. It's Hector Gomez, who is here. Hector came on board last fall. He's had an extensive career with the United States Marshal Service. And so we're very happy to have him helping us with these issues. Hector?
Yes, thank you, Chief. Let me tell you a little bit about myself. I have retired December 9th, 2017 from the U.S. Marshal Service. Started here on the 11th, following Monday. So after a 31-year career, I had a weekend retirement. Background, I've been posted in Brownsville, McAllen, Denver, Washington, and Austin. I was the agent in charge in Austin since 2002. I oversaw fugitive investigations, extraterritorial investigations, inappropriate communications with judges, court security in both courthouses that house the principal trial judges at the new courthouse and the appellate judges and bankruptcy judges at the Thornberry building just north of the federal building. Oversaw again multiple jail contracts with sheriffs to house pretrial detention. So my background, I even did a spell with the witness security program in Denver and Washington. So my background is very heavy on security and court security minded type issues, trials, high profile trials. I participate in leadership roles or support roles in Timothy McVeigh, the Unabomber, cartels, white supremacist organizations, motorcycle gangs. So again, my background is very heavy in security and investigations. So again, very honored to have been named the first courthouse court security director for OCA. So with it, I certainly want to impart the depth and breadth of knowledge and experience that I have acquired over 31 years and apply that here in the state. So going forward from here, certainly what we've done on January 12th was David Slayton distributed an email blast statewide advising all members of the judiciary of SB 42 and the privacy protections that were afforded members of the judiciary. A link was provided in that email blast, and we reached, again, virtually all members of the judiciary, state judiciary here in Texas, where that information process will allow us to provide the Texas Ethics Commission, county registrars, county appraisal districts, and GPS with that personal information for these protections to apply. So those processes are in place and going on as we speak. To date, being that we're at the 6-week mark at this point in time, we have about a 15% response to that email distribution that was sent in January. In the meantime, what I'm doing going forward as well is I've been invited to several court security meetings throughout the state, principally in, as of recent, Bexar County and Valverde County. And I've addressed court security matters, court security issues, made recommendations, and sat as a participant and an observer in these court security committees that are having ongoing discussions in their particular jurisdictions. So I'm going to continue to do that and make myself available for that purpose. I have pending presentations in Dimmitt County, Burnett County, and a few other counties here in Texas, again, to offer my insight, provide an anatomy of SB 42, and certainly seeking the judiciary's assistance in complying with these privacy protections. We've also, here at OCA, with the Court Security Division, have had the opportunity to discuss the anatomy of SB 42 with conducting presentations with various judicial training centers, namely the Texas Justice Court Training Center, where they've had seminars in San Antonio and Austin, where I was able to get in front of justice members and other members of the judiciary, and again, just reinforcing the importance of complying with the SB 42 law that provides them these valuable protections. Going forward along with that, I'm continuing to make myself available and have pending presentations in Rockwall, Lubbock, San Antonio, and with the assistance of the spring conference sponsored by the Texas Center for the Judiciary, the spring judicial education session for county judges sponsored by TAC in Lubbock, and pending presentation in Houston for the annual judicial education conference sponsored also by the Texas Center for the Judiciary. So there are ongoing efforts at this time where I am making myself available, getting myself in front of an audience of judges, and again, just explaining the importance of SB 42 and more so the importance of having members of the judiciary comply with these protections for them. I'm also making recommendations and making sure and reinforcing that these court security committees are established, that's a responsibility now that's now thrown upon each county jurisdiction's municipal jurisdiction. So again, we are using various modes and mediums of to make this outreach statewide. Court Security Division has met with representatives of, as I alluded to, several judicial training centers, the Texas Center for the Judiciary, Texas Association of Counties, Texas Justice Court Training Center, Texas Municipal Courts Education Center, and the Texas Justice Court Judges. We have partnered utilizing their press outlets, websites, and newsletters. Again, we feel that OCA is making that outreach in multiple fronts, and will continue to explore alternatives to reach every member of the judiciary to continue to reinforce the importance of complying with SB 42. Now, the Court Security Division is continuing to field calls, answer questions, answer unique concerns from the field, from members of the judiciary statewide about court security committees, unique and personal circumstances, and request to conduct facility surveys, court security committees, guidance on security-related issues. I've made myself available, and we continue to be very, very aggressive in that area. The Court Security Division in OCA has established a webpage, and that unique webpage, dedicated webpage within our website, provides resources for our client base. It provides guidance and templates, and we're continuing to build to have this resource available for our client base, mainly the judiciary and also the law enforcement components that have a responsibility to report court security incidences. Court Security Division is developing resources, and as I alluded to, we'll continue to address unique circumstances and issues with the judicial members as they come across, again, circumstances that may be unique to them. The Court Security Division has also outreached to all 254 sheriffs, elected sheriffs in the state, advising them of SB 42 and their potential to have some responsibility to report court security incidences to OCA. So I think, again, our outreach is aggressive, it's very broad, and in some instances, as I'm hearing, some judges are hearing of this effort 2 or 3 times, which is very satisfying to me. If I could refer you to a handout you may have sitting before you, it's the 2017 summary of incidences, statistics of FY17. As you know, we concluded the year FY17 with 118 court security incidents reported to OCA. We have provided that statistics summary on our website now. And what I did, I took the liberty of taking a comparison snapshot and being mindful that we're a few days shy of the 6-month mark from 9/1 of 2017 to now. I took a snapshot of also current and a year ago, the same 6-month snapshot. And right now I can report that we have a 173% increase in court security incident reporting. Now, that I can attribute to a couple of things. One, we've got a good reporting mechanism, a good reporting platform now. And now principally law enforcement, who is now responsible for this court security incident reporting, are becoming aware of this process. And as we make our messaging efforts more statewide and broad and get the word out there, we're going to see, I believe, in my mind, in my view, incidences increasing as far as reporting is concerned. So again, much of the Court Security Division's campaign in the last 60 days has focused much on messaging and outreach, having these entities become aware of what they now have to do. And mind you, with this 173% increase, we only rolled out the new reporting scheme and the email distribution on January 12th. So this is, again, very encouraging. Concluding, much of the Court Security Division's campaign, as I said, is focused on messaging and outreach. Going forward, we're going to continue to reach new active and retired judges, advising them, of course, of the importance of complying with SB 42 and the privacy protections. With regard to court security incident reporting, we've updated and reported our reporting scheme has improved for the end user, which again is principally law enforcement. It'll serve as an easier platform to report and quantify the related incidences. Having rolled out this platform in January, again, I remind you we've seen an upward trend in reporting, and I attribute that more to everyone becoming now aware of one's responsibilities and requirements. I have availed myself to various entities, counties, concerning court security incidences and establishing court security committees, and will continue to do so in my effort to reach all 254 counties. So again, that is about what I have for a busy couple of months, and thank you for your time.
Questions of Hector? Yes, Kevin.
Go ahead. Just a comment and a question. I responded to the survey and heard from the voter registrar in a couple weeks, so it's working. But I had a question on, is there a deadline for judges to respond to that? Because we've noticed a number of municipal court judges, I guess, haven't read their email, so we're trying to tell them about it at the regional seminars, but is there?
No, sir, this is an ongoing effort.
Okay, so we'll just keep telling them.
Exactly, we'll keep reminding them, yes, sir.
Thanks.
And just to note that we've gone through so we have approximately 3,000 judges in the state. We've gotten 600 and something, approximately 600 responses. So the staff have gone through and looked who's responded, removed those email addresses, and on Monday a reminder will go out to all the judges who've not responded, just to remind them. We think this will be the last reminder because we don't want to bug judges over and over and over again, because maybe some don't want to do this, but we figured some might have missed it in January and we sent it out.
Just
so we're
don't
going to
read
send it again. And then, as Hector pointed out, as you just mentioned, we're asking all the training centers who work with judges to help push that again. And as you've just noted, as we get those in, our staff are taking them and getting them to the Ethics Commission, getting them to DPS, getting them to appraisal districts, getting them to the voter registrars, asking them to remove the information. And so far, all the entities have been very responsive, and we're grateful for their assistance.
Kevin?
And this may be that's not what you've mentioned several times, judges needing to comply with SB 42. Is that what you mean, is just sending this information and responding to this?
I'm wishing they would comply. It's voluntary.
But is that what you mean by compliance?
Yes, by actually filling out the survey, the questionnaire, where we get the data and present it to the 4 entities.
And then at that point, the judge's responsibility is done.
That's correct. That's correct. It's a very simple process. It just relies them inputting the information, and we take it from there.
So how are you planning on doing the training for everybody?
With regard to court security, and well, a lot of it's based on my experience and resources that I have available. One that I've custom made from my previous career in the Marshal Service, where I've applied some of those very similar resources and templates, and then again just cutting and adapting them to a rural setting, an urban setting, things of that nature. We have opt-out features that we're looking at providing for the judiciary so that the judiciary has options to opt out of websites, for example. It's ongoing and building. Yes, sir.
The guidance and templates, what I've heard from my sheriff, this is hearsay about other sheriffs, is that they're not sure how to promulgate policies and procedures. And of course, it varies from rural to urban, and it's largely dependent on economics. There's only so much you can do in some counties to provide security devices and personnel. What are you doing to provide specific template examples for urban communities and rural communities for their security committees? Because that's the biggest burden for local communities, is to comply with the law by developing a security committee which promulgates policies and procedures. What are you doing in writing to give those templates and guidance to those committees?
And to take it even one step further, we're even looking at historical courthouses as an issue. They're inherent issues. So what we're doing is taking a zero cost, where just simple policy changes, court orders, and then gradually coming up with tiers, developing tiers, moderate costs to make some of these fixes.
Are you going to suggest some template policies and procedures that local committees could consider adopting?
Yes, and I have even provided some. I haven't quite finished the end product, because I'm still working with leadership on these issues. But off the cuff, I've been sending some judges that were just, I believe, were in need now to get something on hand, put in their hands, that I've provided that for them.
Will that be on your website? In other
Yes.
words, are you going to have grade A policies and procedures, B, C, things you should consider alternatives?
Yes.
Will it be that defined?
It will be that defined, where it's going to give the client base, the user, options, just to look at or use or adopt as a template. Again, they're templates, so you'll be able to build and edit as according to your, again, your environment.
Thank you.
Thank you.
Yes, Senator.
Thank you. Have you made an effort to work with the sheriffs and the county clerks and other people impacted by Senate Bill 42?
My outreach has been individually with sheriffs. I have spoken with several sheriffs. Some have brought unique issues to me. They want me to go down there and address it in a more of an audience platform, which I've been more than willing to. But mostly, again, what I'm facing is an urban, rural, very rural, and non-existent court security posture that they have in place. So individually, I'm working with these sheriffs one-on-one, giving them guidance, my recommendations, how they can at least jumpstart a non-existing court security process.
And do those with whom you have worked understand that we are addressing not only the security of judges, but also the security of all who work or visit or conduct business at the courthouses?
Yes, ma'am. In fact, my standard language is always the judiciary, the employees, and the general public are the three main focus of a good court security plan, is taking those three elements and encompass them in their whole approach.
Have you identified any weaknesses or gaps in Senate Bill 42 that we would have to address next session?
We have discussed, I have brought some issues to leadership's attention, and we're working, and the general counsel, and we're working through those, but I anticipate that there will be a few fixes. Yes, ma'am.
Anything you can share now?
I can share one.
All right.
One of the questions we're getting is whether or not the judicial court security committees are subject to open meetings. You know, it's in the judicial branch, which is not technically subject to open meetings, but there's some question because it's not 100% clear. And of course, the court security committees are very concerned about discussing specific court security matters in a public forum. So we need to clarify.
Plus open records. We're concerned about that now too.
Right.
What can we put in our minutes, what not? What can be seen, by whom?
Right. So that's one thing I think we need to clarify in the law. That is something we've heard from a number of court security committees really worried about that. And obviously that's constraining a little bit about what they're willing to talk about, because they don't want to be talking about, oh, there's this door that you can get in and we need to figure out how to fix that, and then all of a sudden it's now public.
Should we ask for Najee's opinion at this point?
We could. I mean, we've been advising, the judiciary has certain things, you know, even if the judiciary were to be subject to open meetings act for this purpose, we've been advising they can go in executive session for security purposes. So they could post their meetings, they could go in and convene the meeting and then say, we're going into executive session to discuss security. So there are things we could do, we're advising them to do now, but we would like to be able to fix that in the law ongoing. And it's things like that. I think it's little small, minor tweaks of things that maybe we didn't think of at the time. They're now presenting themselves that I think we'll need to
But we're
address.
talking about probably April or May of 2019.
That's correct. So what we're advising all the committee, I mean, what we've been telling them is, obviously you can consult with your lawyers, but our recommendation is that even if you are subject to Open Meetings Act for these purposes, you can go in executive session. So we're advising them to do that, to be able to hold these meetings and discuss what they need to. And obviously, in executive session, those things don't have to be made public.
And you can appoint task forces and subcommittees, which I've already done, to make it tighter, more nimble, and just, they don't have to be posted, they can meet informally, then they make recommendations. That may have to be formal, but that can be done more just, with some caution. Now, these are problems.
Would a statement of legislative intent help at this point?
I suspect it would be helpful, and we could probably work with, a couple of the authors on the bill and probably get that done. Many of whom are sitting in the room today.
You could do that.
Yeah, so I may ask you all for something like that. We could do an AG opinion. There's always risk to asking for an AG opinion because you may not get the answer that you want. So I think we'll have to explore that, but certainly maybe something that would at least provide some cover for, and something we could give to the local court security committees to say, hey, this is a statement of legislative intent as to what they intended.
We have 4 legislators to begin with, so we can do that.
I have one comment that I'm receiving from some constituents, and it has to do with former or retired judiciary, or those that are now, but they're going to be former or retired. And it doesn't have to do just with protecting their personal information, but addressing security concerns, and that goes in a whole bunch of different directions. I suspect that we may want to give some thought to that, because that might be another topic that's addressed in the next legislative session.
One of the things that we have, we're sort of, there's a lot going on right now.
Yes.
And our court security division is standing right there. That is our court security division. Lots of other staff who are assisting, thankfully. But one of the things that we have not done yet, that is the next step, and we just talked about this day before yesterday, is making sure the law does apply to former and retired judges. But there's not been a lot of outreach to those folks yet. So we've been talking with the regional presiding judges to ask them to assist us in making sure that those judges know about the protections that apply to them as well. So we need to keep working on that.
Yeah. Next week, Mr. Gomez has an article going out in the Texas Center for the Judiciary's In Chambers periodical, which will go to 1,200 county court, district, and appellates, and it will include all the retired and farces. And he put in links they can access to report incidents and things like that. So they'll be getting that in the mail this coming week.
As Hector mentioned, a lot of outreach going, and I want to commend all of the training entities. Hector and Scott met with all, and they were all willing to do whatever they could to help. It's been, judges are getting this, as Hector said, from lots of different directions, but hopefully at least one of those will they'll at least hear it once, maybe multiple times, but at least once.
That would not have been my answer, Senator. My answer would have been an appropriation to help us so that we don't have to make bricks without straw up there. As David said, Hector is our court security division. And as everybody at this table knows, the state is so incredibly diverse. And particularly in this area, Houston is not Lubbock, is not Laredo, is not Brewster County. It's just a myriad of circumstances and officials, almost all of whom are elected, to deal with. So it's really a challenge. But I think we will show by this time next year that we've made great progress, that there's still a lot to be done, and we need a little more help.
I went into Hartley County Courthouse a couple of weeks ago, and about 3 or 4 in the afternoon, there was one person in the courthouse. And so, their security obviously is different from Harris County.
Chief, one more thing I'd say. The other thing that's really, I'm really happy about Hector being here is because now that judges know this resource exists, he's getting a ton of calls from individual judges who have very specific security concerns. I'll just give you two to put a face to what we're dealing with. We have a judge who received 2 voicemails. We have the audio of them because they were recorded voicemails. With an individual threatening to kill that judge and making Columbine look like nothing. That's what they said on the voicemail. The second was a judge who had a litigant who was very upset with the judge, who rather than going to the judge's house to find her, drove 60 miles to her parents' house, knocked on the door and said, "I'm looking for so-and-so and I'm not happy." And the disturbing thing, those are obviously disturbing on their face. The even more disturbing thing was both judges called Hector because they said, "I reached out to law enforcement and law enforcement told me there was nothing they could do." And so the nice thing was Hector turned around and with his law enforcement connections, reached out to the law enforcement entities, reached out to Texas Rangers, and immediately those entities jumped on it. And so that's a resource that judges haven't had before. And I don't have the type of relationships where I can pick up and call the Rangers and the sheriffs and all that and say, "Hey, we really want you to do this." They might do it, but when they have someone who they've worked with in the past they know has a law enforcement background, it's been very effective. And I'm really glad that judges have that. I visited with Hector earlier this week, and he said one of the things he's hearing is some of these judges are just calling because they just want someone to talk to about this and make them feel like, yes, that's something you should be concerned about, and understand and hear from someone and get some tips from him on things they can do personally. And it's been a really rewarding thing already in just the 2 months that we've had the position, and judges are beginning to use it. So I'm sure that'll keep building. And yes, Chief, I agree with you. A few additional people would probably be helpful to help us address our mission.
So what was the answer? The law enforcement says I can't do anything. Texas Rangers and XYZ Force say what?
Say they can, and
what is it?
Making a visit to the individuals,
Knock and talk.
and look into the incident and see if there's a criminal activity that occurred that could be charged, or if it's just basically a message of you better stop, or we're going to, or monitoring. So a lot of things going on that front. But the law enforcement have been very responsive when Hector's reached out, which has been great.
Well, the legislation was a recommendation of the council, and we deeply indebted to Chairman Smithy and Senator Zaffarino for carrying it for us to successfully end, and for Judge Kusurek, who inspired us to take this on. So, thank you for the progress.
And to you and David for your leadership and help. We wouldn't have passed it without you, I'm sure. It wasn't easy, as you know.
Yeah, right. Nothing ever is. Except bad things. We'll go to the legislative interim charges. Megan would usually present those, but she can't be here this morning, so Dave, if you would.
Thank you very much. I don't know where the clicker's at, so we'll see if I can find it. Megan asked me to let you know that she's sorry she can't be here today. She has a young child who was diagnosed yesterday with pneumonia, so please keep her family in your thoughts, and strep throat. So she's home. I advised her to stay home with her child today, and that I would do my best to cover for her. As you probably know, obviously the Judicial Council has interim charges in and of itself where the committees are looking at various issues, but the legislature also has charges which the Lieutenant Governor and Speaker have charged each of the committees. And there are a lot of them. The House, the Speaker laid out 237 separate interim charges for the House, and the Lieutenant Governor laid out 105 interim charges for the Senate. Obviously, I'm not going to go through all those today. You were provided in your materials a list of all of them, and you're free to read all of them. I'm going to try to highlight the ones that deal with the judiciary. Some of the committees are meeting and have been meeting, but most of the interim hearings will likely be held after March. There's a little election coming up, which has the attention of a lot of folks who would be holding these hearings. So after March, we'll probably get ramped up pretty quickly. The goal of these committees will be similar to what the Judicial Council's committees are to produce interim reports before the start of the next session, and many times bills will come out of those reports for action. Senate State Affairs Committee is the committee with primary jurisdiction over the judiciary. in the Senate, and they have one charge which they will be looking at. You'll see this charge again on the House side. But one of the big issues that has come up, and the council has previously looked at this and made recommendations, and maybe we may look at something again this year, but court fees are very, very difficult. I always say it's the best game of Twister you've ever been a part of, multiplied by about 1,000 if you want to try to figure out the court fees. And any lawyers who are in the room that practice know that you generally send, if you're taking a filing to the courthouse, you send someone with a blank check because you have no idea what it's going to cost to sit there because of the difficulty of our court fees. There were also some cases that have come out of the Court of Criminal Appeals striking down certain court costs as unconstitutional. And the council previously has looked at the use of court costs for purposes that are outside of the judicial function. And so some of these things will be looked at by the Senate State Affairs Committee and the House Judiciary and Civil Jurisprudence Committee. So that's one of the things that they're looking at. The Senate Criminal Justice Committee is looking at a bill that the council recommended, that is Senate Bill 1326, which was Senator Zaffarini and Representative Price, Representative Murr, bill regarding mental health. This is the mental health bill that came out of the council, the recommendations. So they'll be looking at how it's being implemented, what changes need to be made to it, and how the duties that have been assigned to OCA and the judicial system are being developed. So we're monitoring that. We'll be involved in providing feedback on that. We're looking at working with a lot of the courts with regard to certain issues, and undoubtedly there will be some tweaks that need to be made to that legislation as well. The Senate Health and Human Services Committee has a number of charges which are closely related to the work of the council and other committees commissions and committees within the judiciary. Child welfare is one of them, obviously looking at the CPS system and how it's working, specifically with kids who are in permanent managing conservatorship and those who are aging out of state care. Just for everybody's benefit, this is not an issue I knew about many years ago, where we have a significant number of children whose parental rights are terminated and then they turn 18 and they don't have, what'd you say?
And they turn what?
They turn 18 and therefore they become an adult with no family, legally no family. And you can imagine the difficulty that imposes upon them. And there's been a significant effort made by the judiciary and by CPS and others to try to make sure that we don't have kids who are aging out without some permanent family legally. So the committee will be looking at that issue. The committee will also be looking at substance abuse and opioids, something that our Criminal Justice Committee is looking at, how we can do a better job of addressing that issue. And then they'll be monitoring things such as the changes to the mental health system. Our mental health committee has looked at the delay of someone getting into a mental health institution for competency or other types of mental health treatment, and they'll be looking at that as well as the new funding that's been provided to construct new state hospitals and community grant programs to allow counties and cities to make improvements in mental health. So those will be all very interesting interim hearings that we'll want to be a part of. The House Judiciary and Civil Jurisprudence Committee, chaired by Chairman Smithy, who is here today, has a lot of charges that are related to the Judicial Council and the Judiciary. The number one there is looking at the effects of Hurricane Harvey on the courts and legal system. Virtually every committee in the House was charged with looking at Harvey and its impacts on whatever was under their jurisdiction. So the Judiciary and Civil Jurisprudence Committee will be looking at that. We've had some conversations already with Chairman Smithy's office about some of the issues related to Hurricane Harvey, and there'll be some things we'll want to be looking at there. And I provided you all an update about that last meeting. Also looking at online type dispute resolution, other types of ways of resolving legal disputes, and some of that information is something the Civil Justice Committee is looking at, and the Judiciary Committee will be looking at that as well. The fees issue I've already talked about is a charge that this committee has. The fourth one up here is looking at specialty courts, drug courts, DWI courts, mental health courts, how they're being used in the state, and recommending improvements to make sure that they're appropriately and successfully utilized. They are an expanding operation within our court system, and the legislature wants to make sure they're being used appropriately. The fifth one is looking at the jurisdictional thresholds of the justice, county, and district courts, something the Civil Justice Committee is likely to make recommendations on as well in this area, so we'll see kind of how that goes. The fifth one is looking at the guardianship compliance program that we have here at OCA that we've talked to you about previously, and whether or not that is effective, and whether or not there are other things that need to be done to ensure people under guardianship are protected from abuse. And then lastly, a recommendation, a charge to monitor the implementation of the statewide electronic database of court records, or Research Texas. It is our online system that is available for judges, attorneys of record, and clerks to look at online court records that are electronically filed. That system became available for attorneys of record on January 1st and has been used across the state. So there's a charge for them to monitor the implementation of that system. The House Committee on County Affairs is going to be looking at basically mental health in relation to defendants and inmates, and making sure they're getting the rehabilitation and transition services that they need, and that they're getting the appropriate amount of mental health treatment whenever they get released from the criminal justice system. So that'll be one that's related to our mental health work. House Criminal Jurisprudence is going to be looking at pretrial risk assessment, specifically in the charge, the work of OCA in developing a pretrial risk assessment tool, which you've heard about previously in one of these meetings. And then also they're required to be monitoring the litigation out of Harris County's pretrial bond, regarding Harris County's pretrial bond practices, which I know Judge Moore's going to update you on in a few minutes. And also looking at any sort of legislation regarding imposition of fines, fees, and court costs in criminal courts. So they're also kind of looking at that issue about fees and fines. The House Select Committee on Opioids and Substance Abuse. This is a special committee appointed by the Speaker in this interim to look at opioids. So their work will be very closely related to the Criminal Justice Committee's work. They'll also be looking again at specialty courts, those drug courts, DVAC courts, to see how those are working and whether or not any changes need to be made to the law. Lastly, there's a joint committee between the House and the Senate that is looking at the all-important issue of judicial salaries. This committee was just appointed in the last few months on both sides. You can see Representative Ray will be the co-chair along with Senator Huffman, along with a couple other members. Representative Smithy is on that. This committee's charge is to look at whether or not there is a way to establish a formula for setting judicial salaries that the legislature could look at implementing. There was some movement in some bills. The Chief Justice Hecht recommended during his State of Judiciary a new way, and so there's going to be an interim committee who will be looking at that issue over the next few months. So hopefully they can come up with a plan that addresses judicial salaries. I'm happy to answer any questions you may have about interim charges, if there's any.
Questions for David?
Thank you.
Thank you, David. We will be, this group, I hope, and other groups will be making some real pushes on some of those issues like compensation. So we're grateful for the legislative committee looking into it too. So we'll have developments. We'll go to the report of the Civil Justice Committee. Chief Justice Bradley.
Okay, just as a reminder, the Civil Justice Committee was given the charge to study the conference of the Chief Justice's Civil Justice Initiative recommendations and the landscape of the Texas civil justice overall, and to recommend necessary reforms to improve access and make it more user-friendly. The Council of Chief Justice's objectives was to enable the courts nationwide to implement these initiatives and recommendations to improve our civil justice system and thoughtfully implement them so the recommendations are responsive to the needs of the users. We are being helped by the Institute for the Advancement of the American Legal System and the National Center of State Courts, who is the umbrella organization of the Chief Justice's Conference. They are providing significant assistance for that. And they gave, the Texas Judicial Council gave the committee a general guideline as to present to the next legislative session for committee work. We met last fall, the Civil Justice Committee met last fall. We had a vigorous discussion about civil justice reform. And we also had a presentation from Brittany Kaufman, who is the director of the Institute of the Advancement of the Legal System, which is located in the University of Denver. Big challenges outlined at that committee meeting were vanishing trials, declining civil filings, costs, delay, excessive adversarialness, congested dockets, courts that are disruptive, and access to justice for pro se litigants. The committee agreed that we should have an advisory committee to give us good advice to address those challenges. So an advisory committee was formed in that last week, which was facilitated by Brittany, who I just spoke about, the Institute of the Advancement of Legal Justice. What is it called?
Legal system.
Can you tell me?
Legal system. Yes.
Okay. Anyway, so those topics that were discussed. Would you want to take over this?
Sure. Chief Justice Raddick was supposed to chair that meeting, unfortunately was under the weather, so she didn't get to come. So I had to fill in for Chief Justice Raddick, which was a very difficult task. The advisory committee is about 25 folks. We have judges from all different levels of court. We have lawyers. We have business community, apartment association. We tried to get people who represented all facets of the civil justice system. We spent about 2 days going through specific areas of discussion and trying to flesh out problems and solutions. At the end of it was a very engaged group. They provided a great deal of input to us that will ultimately form, I guess, the recommendations from a lot of the recommendations from the Civil Justice Committee. So because that happened last week, we don't have a full report for that, but I think there were 12 or 15 big, huge Post-it notes full of ideas and solutions. So those will be something that the Civil Justice Committee will be looking at for recommendation back to the council. It was a very good meeting. I was really impressed with the ideas and some things that could perhaps dramatically impact the civil justice system in a good and positive way.
The last thing I just want to say is thanks to OCA. They provide incredible assistance, as I'm sure you are familiar with, but especially David, who's been very helpful. So that concludes my report. Anybody has any questions?
Questions of Chief Justice Raddick? Well, we look forward to that. I visited with David about the meeting last week and stopped in for a minute, but they look like they were hard at work. So I think we do have some good possible ideas for improvement. We'll hear final report in June.
Well, the advisory committee is going to report. That report will go to the Civil Justice Committee, which will meet again, and we will hopefully have a report for Texas Judicial Council.
We'll go to the Criminal Justice Committee. Judge Moore.
Thank you, Chief. The Criminal Justice Committee met on January 26th here in Austin, and I'm going to cover a couple of things. Our work right now leading up to the session is concentrating on the two charges, one related to the opioid epidemic, and the second one, which continued from last session on the pretrial release issues. Those are the two main things we're looking at. At the time we met on January 26th, the Fifth Circuit had not issued its opinion, but 9 days ago did issue its opinion in the Harris County bail case and upheld most of what the district court did. One thing that we did notice is that the court cited favorably some of the efforts the state had attempted last session as far as reforms. And so we think that's a really good starting point as we go forward into the next session. We know that these things, one thing I do want to point out, the decision, as I understand it, was really based on Harris County's process before all of this came up, and Harris County's made a lot of changes that are not reflected in the court opinion. And so they've made a whole lot of changes, but a lot of the things in the court, I want to thank OCA because I want to read something from the opinion to you. It says, in essence, you can take two misdemeanor arrestees who are identical in every way, same charge, same criminal backgrounds, same circumstances, etc., except that one is wealthy and one is indigent. Applying the county's current custom and practice, with their lack of individualized assessment and mechanical application of the secured bail schedule, both arrestees would almost certainly receive identical secured bail amounts. One arrestee is able to post bond and the other is not. As a result, the wealthy arrestee is less likely to plead guilty, more likely to receive a shorter sentence or be acquitted, and less likely to bear the social costs of incarceration. The poor arrestee, by contrast, must bear the brunt of all of these simply because he has less money than his wealthy counterpoint. And that was what the court said in finding that it violated equal protection. And they also found that the system violated due process rights under the 14th Amendment. But anyway, a lot of the things our committee has discussed and is discussing are things that were mentioned by the court in here, not citing our committee. Don't get me wrong, but they're the same issues that we've been talking about, and the same direction we were headed. So we feel good about that. In our next meeting, we hope to hear from Harris County. We weren't able to get Harris County or Nueces County to our last meeting, and those are two of the two groups that are moving forward using pretrial risk assessments. And the thing I talked to y'all about at our last meeting, they're the people that we hope can go to the legislature and say, here it is, here's what's working, here's what's not working, and here's how we can make progress. And so that's where we're headed with our next meeting. As to the opioid crisis, the committee's working on a survey for Texas judges to determine. In my personal survey of judges, I'm finding what has already been discussed here this morning, and that they're not seeing a big issue with opioid addiction in the courts in Texas. That most of what they're seeing is still meth related. But we want to go ahead and get to the courts and be sure we get to the misdemeanor courts and other courts where these may be having impact so that we get a full picture. Megan is working on that survey now. We hope to get it out soon so that we can have results by the time we next meet in early April. And those are our two main issues, and that's what we've been doing on it.
Questions of Judge Moore? Yes, Dave.
Just want to add one thing for everyone's benefit, and I know Judge Nash probably knows this very well. Dallas County has also been sued in federal court for its bail practices, similar to the lawsuit in Harris County, except that Dallas County's suit involves both misdemeanors and felonies, versus the Harris County suit, which only involved misdemeanors. We'll see what happens with that. That was just filed probably about a month ago. And as you may know, we've been working with Dallas County to try to implement pretrial risk assessment for the last couple of months, and we will continue to do that. But they have been sued in federal court with a similar case that was filed in Harris County.
I want to say one more thing that needs to be on the table. We talked about this last session. The opinion references a lot of what the pretrial services are doing and not doing in getting information for judges. And we as a judicial council have to remember that the vast majority of our counties do not have pretrial services. They're very limited in their ability to do a lot of these things that the larger counties are able to do. And we're going to really have to take that into consideration as we make our recommendations.
Thanks, Judge. Thanks for your report and good work. We'll go to the Data Committee report. Judge Rubel can't be here today, but
I'm actually going to let Scott do it instead.
Good morning, everyone. I'll give you a quick update on the work of the Data Committee on behalf of Judge Rubel, who couldn't be here. Just as a reminder, the Data Committee is charged with a couple of things. The biggest thing, perhaps, is overseeing the work that we're doing at OCA to move to the collection of case-level data. This was brought up before, Angela referred to it. This is a significant undertaking, and getting to where we want to get will require a significant amount of planning and thought and engagement from clerks and others who are involved in reporting data to us. The second thing, which has already been done, is the committee weighed in on some changes that were required by statute last session on the part of reporting from our presiding judges. Mena Ramon and Angela Garcia worked on that, and that reporting began in January, is that right? And then third, the committee is charged in collaboration with the Criminal Justice Committee in taking a look at specialty court data. So this is data that is reported to the state, not to OCA, this is to the governor's office, from our drug courts and our mental health courts and our veterans courts, to take a look at the reporting environment there and to make recommendations about how that can be improved. And OCA has received from CJD, particularly in the area of mental health, we've received from CJD the full data set for last fiscal year for all offenders involved in mental health courts around the state. And we've just begun looking at that, but we're very grateful to the governor's office for their responsiveness and their willingness to work with us on that. The data committee last met on January 29th, and in addition to committee members, we had invited guests from the County and District Clerks Association who were also there. At the meeting, Casey Kennedy, OCA's IT director, provided an overview of judicial branch strategy, and Angela Garcia, who we heard from just before, provided an overview of the collection and use of judicial branch data. A deep dive, I guess, and a behind-the-scenes look at what's required and what goes into the good and the bad and the ugly and everything that goes into the preparation of the statistics that we looked at the beginning of the meeting. After each of those presentations, there was significant discussion, which was focused on differences across jurisdictions around the state with regard to the technology infrastructure. And Casey, that one slide that you had that I thought was so helpful was a description of, at the trial court level, counties pay for IT in our trial courts. And in some cases, in the larger jurisdictions, there's a dedicated office within the county that's focused on supporting courts' IT needs. In other jurisdictions, typically the smaller ones, courts may have the support of a dedicated IT shop, but that IT shop is also providing support to other units within county government, not just the courts. And then in other jurisdictions, the IT services may be provided by a vendor, and then in our smaller jurisdictions, we may not have any IT support that's provided to our courts. So there was lots of questions about that, and some discussion about what the implications are of that reality for our interest in and our need for, here at OCA and with the council, for some standardized quality of reporting and uniform reporting. And Angela's discussion, I think, was really benefited from the way, Angela, you contextualized the discussion about what we get, who we get it from, and what we do with it by looking at the mission and the charge of the Judicial Council in this area that's in statute. And perhaps this is on the top of all your minds when you're sitting in this room, but in case it isn't, the council is charged in the government code with gathering statistics and other pertinent information about judges and other court officials. And the purpose of that activity is to support continuous study of the courts and methods for their improvement, and to consider advice concerning how to remedy faults in the administration of justice, and to design methods for simplifying and making more efficient the whole judicial process. One of the things, of course, that we struggle with on a regular basis at OCA is how to make the best use of information that is not always complete, as is reported by clerks and others. Of course, it's aggregated at the county level, and the limitations that are associated with that. And so Angela gave some good examples of the kinds of questions we get that we're not typically able to answer. Things, for example, Representative Murr, questions like the one you asked earlier about what's going on, can we unbundle or unpack this trend that we see in a particular trend or case type. And in some cases we can, but in many cases we can't. And in other cases, what we have to do, David gave a good example of this, is go outside the branch and try to triangulate and figure it out that way. We've got a dedicated and very capable and skilled information services staff, but often this can be a lot of work, which is one of the reasons why we're looking at the capture of case level data. One of the things we talked about was the full range of information that's required to be reported to OCA. Some of those requirements are in state law. Many of those requirements take the form of Judicial Council rule. And it was very helpful to have the two clerks in attendance. And Judge Gravel, we got their input along the way during the meeting. They were invited and felt very free to speak on the issues that we were discussing. But he asked, Angela asked staff, and Angela took the lead on this, to develop a survey that could be sent out to clerks, asking them several questions about the issues we're discussing. One was, what information that that clerks are currently required to report, do you clerks never have any activity to report, or that you're simply unable to report? And I should have mentioned in the context of the comments I made about Casey's presentation, perhaps this is known to most people here, but there is not, of course, one case management system that our trial courts use. There are, how many?
20. They can choose, and they choose between roughly 27.
Yeah. So the ability to report and to satisfy the reporting obligations varies from county to county, and in some jurisdictions where those systems are robust and modern and well maintained, it's a little bit easier than it is in others. So we asked clerks to give us some feedback on that. We asked them to tell us what information we ask them to report, or the legislature asks them to report, that they consider to be trivial or unimportant. We asked them to let us know what information they have to track and report to us manually rather than electronically. And finally, we asked them for their input on what they might like to see collected in the future, which is also a question that will be front and center for the committee. The good news, I think, is that these are great questions, timely and relevant questions. The bad news is that we only had 17 clerks respond. The survey went out at the end of January, and this is as of a week ago. We had 17 responses, which is obviously a very low number. You can look at it one of two ways. I guess the optimist in the room would say, well, I guess no news is good news, and we'll take no response as with some understanding that whatever we decide to do will be terrific. The other way of looking at it, I suppose, is that people either didn't see it or are still working on the responses. So we'll talk to Judge Gravel about how to do the follow-up there. And the committee is planning another meeting to look over the survey responses and some other information that Angela's put together sometime in late March.
Questions, Scott?
I have a question.
Yes.
How are, at one point or another, I guess, the whole data needs to be considered universal in a way and accessible from all points and angles. Is it a consideration to make this more like a big data lake where analytics play some role there, and where actually it's secure, highly secure, like maybe high security such as in Bitcoin coding security, any of that?
Yes. The short answer is yes. Currently, all of the data we collect is available to anyone who wants to see it, again, at the county level in a system that's maintained here at OCA. But a part of the case level data project is the development of a business intelligence tool and the development of dashboards and things like that that will be public facing largely, but also some privately facing utility. So that's absolutely part of the plan.
So who is responsible for the development of intelligence right now?
That'll be...
So Scott, let me jump in. So from a technical level, we are envisioning a data lake with a BI tool, third-party BI tool sitting on top for two groups. Public access to provide that transparency in government, but then also a more robust version of it so that Angela and the team can answer those deeper questions like how many cases are we getting on this and this, that they can dig in and slice and dice. The other end game with that is to be able to have it set up in a standardized enough way to where some of our other data partners like DPS, HHSC, those other agencies that we want to interface with to bounce our data against theirs so that we can make even deeper decisions. The vision for that is there as well. The point we're at right now is, again, with the data committee trying to tell what questions do they want answered so that when Angela's team comes to IT to say, these are the elements that we want to collect, that we're collecting everything at the minimum amount that we need to collect to be able to answer Angela's questions, for her to be able to answer the data committee questions and judicial council questions.
And how about the terms of security? How is that being protected?
So we're required by law to meet all the executive branch security standards. So right now, because we haven't gotten that far with the data committee, we haven't actually dove down into the level of where it's going to live and how the security on it's going to work just yet.
Because I believe that's very important. We just
Absolutely.
being hacked by everybody.
Absolutely.
So what tells us that we're not going to be hacked?
Right. Well, the nice thing about, or at least at OCA and state government, there's at least 3 layers of things that we do to segregate things, and we work with our executive branch partners. So like all of our internet comes through the statewide network security center, and so they're monitoring up there, we monitor down here, and then we've got protections at all along the way.
Other questions? Thank you, Scott. We've just got to improve our data collection.
We're gonna get there.
We'll go to guardianship, mental health, and intellectual developmental disability committee report. Justice Boyce.
Thank you, Chief. There are significant developments to report, specifically related to a recommendation that this body adopted in 2017 regarding the creation of a permanent Texas Judicial Commission on Mental Health. That is in existence now, and there have been significant developments and steps to make that happen. I would start by highlighting a January 11th, 2018 joint hearing by the Court of Criminal Appeals and the Texas Supreme Court that was held just down the hall in the Texas Supreme Court courtroom, an extraordinary undertaking. All of the members of both courts were present to hear testimony from about 20 witnesses addressing the need for the creation of a mental health commission. These witnesses covered the stakeholder input from a number of different areas: judicial, medical experts, public policy, mental health advocacy, law enforcement, veterans, and powerful testimony of lived experience from individuals who have been affected by mental illness, service providers. It was an entire afternoon set aside and a very strong demonstration of the commitment to this undertaking. That hearing was followed up by the issuance of an order jointly issued by the Court of Criminal Appeals and Texas Supreme Court on February 13th that creates the commission. It will be chaired by Judge Hervey from the Court of Criminal Appeals and Justice Brown from the Texas Supreme Court. The first meeting of that commission will be April 26th, and the steps are currently being undertaken to build out the membership of that commission in advance of its first meeting. In the meantime, this council's Mental Health, Guardianship, and Intellectual and Developmental Disability Committee continues to meet and continues to focus on its areas of interest. The committee met on February 12th. The primary focus of that February 12th meeting is to start identifying areas of potential legislative focus. We're in a little bit of a transition period here. I would anticipate that a significant portion of what this committee has been doing is going to be transitioned to the commission. But while the commission is getting up and running, the committee continues to be active. The areas that we talked about in particular detail on February 12th involved whether there are any legislative adjustments, as David referred to a little bit earlier, that need to be considered for the significant bills that were passed in the last legislative session, particularly the bill authored by Senator Zaffarini, SB 1326, that implemented significant changes to mental health screening, bond practices for misdemeanor defendants with mental illness, and competency restoration under Article 46B for misdemeanor defendants. That inquiry is underway. We also discussed potential legislative action related to guardianship. That will be an area of continuing discussion along with other potential legislative initiatives that I anticipate would be discussed by the committee and then presented for consideration to the commission after its first meeting on April 26th, and also presented to the Judicial Council. So again, we're in a little bit of a transition period while the commission is getting up and running. I just want to highlight two additional aspects that the committee has been involved with. The first is working with David and Megan at OCA to put out very detailed information that is available on the OCA website addressing some of these significant procedural changes that were legislatively passed last time, and providing additional information related to mental health related issues and how those are addressed in courts. OCA has done a tremendous job of getting this information assembled, put in an accessible format, and made available through its website. Additionally, there's been substantial work done by the Texas Center for the Judiciary. Mark Atkinson is here. There will be significant mental health components to next week's criminal justice conference. And then in addition to the conference itself, there's a separate breakout mental health seminar that is going to be focused very tightly on the changes that were made in the last legislative session and other aspects of addressing mental illness and its impact on families and communities and the court system. So there's a lot going on, and it will continue to go on. If you have the opportunity, I would encourage you to look at excerpts from the joint hearing held on January 11th. Very powerful and underscores the continuing need for attention to this area that I anticipate the commission will provide.
Thank you. Just questions for Justice Forrest? I think the first time the Court of Criminal Appeals and the Supreme Court ever did anything together was signing orders in the to suspend procedures because judges couldn't get to the courthouse, and lawyers couldn't get to their courthouse or computers. And it worked very well. So this is the first time we've ever met together. We had to kind of fiddle with the courtroom a little bit to squeeze 18 of us in there. But Justice Boyce was there, and he's exactly right. It was a very powerful afternoon. And so now the order's been signed, and we look forward to the commission getting to work. We've been advised and helped in creating the commission and structuring it by the Children's Commission, which is in this building. Actually, we started it the same way with the same kind of hearing, although we did not involve the Court of Criminal Appeals. They've been a great help to us just mechanically how things could work, what's the best way to get collaboration on these various issues that they're going to be looking at mental health issues that affect the judiciary. So we're not just kind of making this up as we go. We've got considerable experience and assistance there, and enough funding, various sources to try to get a good, solid start, with the hope that we will be able to report to the legislature in the next session some real advance on these issues and show the need for a more robust commission and approach to them. And it wouldn't have happened without Justice Boyce's work and his committee's work. Justice O'Neill mentioned this commission to me 2 or 3 years ago, and it really is a big undertaking, and it took a lot of effort by Justice Boyce's committee to get us where we are. So we have high hopes. I've never had so many people call me or write me and say I want to be on the commission as I have this one. The other commissions, not so much. But so very good, excellent work, great report. The Juvenile Justice Committee, Justice Nash.
Thank you, Chief Justice Heck. We met on December the 18th of last year with the Texas Juvenile Justice Department, Jill Mata and Michael Turner, and also some officials from the Department of Family Protective Services regarding issues related to the crossover youth and how the youth are into both of those systems. Scott has helped me tremendously and is continuing to meet with the Children's Commission and other advisory group members so that we can gather more information on our charges. We have also been talking with having conference calls with representatives from the National Council of Juvenile and Family Court Judges to gather national perspective on the issues being considered by the committee. Also, OCA's intern from UNT Law School is still working on our efforts of ensuring that we are collecting the data required by House Bill 1204. Upcoming, Chief, what we're going to do is schedule another meeting with David, myself, and Scott to talk to the new Executive Director of Juvenile Justice, Camille Kane. So we're hoping to do that coming up soon. And we're also going to schedule a meeting of our advisory group in probably the 3rd or 4th week in March to go ahead and draft our recommendations from the committee. And so again, we are still continuing to work on handling most of our issues related to our charges, but I think we're making some great headway.
Great. Questions of Justice Nash? Thanks very much. I would like to ask the last 4 committees to look at their issues in light of the Florida school shooting. We've talked here for a long time about the need for more standardized gathering of, reporting of information from the courts and a better gathering of that data so that we kind of know what's going on out there. You'll notice that the White House and Senator Cornyn and Governor Abbott have all spoken in support of tighter, better background checks. And part of that information comes from the Judiciary. In fact, David has testified at a U.S. Senate committee hearing on how that information is gathered in Texas. But we have made the pitch that we need this to operate the Judiciary better. But now here is another reason for seeing if we can't get better standardized information. So I think the Data Committee might want to look at that angle on this. And Judge Moore, maybe there's some discussion about whether there should be a criminal justice response to those kinds of things. We had Sutherland Springs shooting, and so is there anything that needs to be done in penal law or procedure to address these circumstances? I don't know the answer to that, but it does strike me that violence against a school or a church ought to be a special circumstance. And it's, it's not terrorism, but it's down that road, it seems to me. So maybe we can look at that, and juvenile justice, whether they're, all these stories about who should have known about the shooter when, and I asked the Children's Commission if CPS has reporting mechanisms or any kind of lookout for these kinds of situations, and so they went, sure, and we'll look into that. And mental health too. Do these events raise issues that make ours, what we've been working on anyway, more powerful, or do we need to adjust? I don't know, but I wish between now and June, y'all would think about that and see whether there are recommendations. Well, we'll finally end up with the Public Trust and Confidence Committee. Judge Blank.
Thank you, Chief. Public Trust and Confidence Committee met in mid-December, and we covered three main areas. Just to review, our charge is to review the 1998 survey that was done in Texas and try to replicate it, update it. Also look at the National Center State Courts have done a number of excellent surveys. And we also, our charge is to recommend any necessary reforms to improve public trust and confidence in the Texas Judiciary. Last December, the three areas that we looked at as a committee, we heard from Eric Vinson, who is the Executive Director of the Judicial Conduct Commission. He went over the process, kind of explained to us. We had some questions about transparency, especially as to complainants, no action items from that. Interesting, one thing he mentioned is that filings this past fiscal year 2017 are up about a third from about 1193 in the previous fiscal year 16. They're about 1,600 in fiscal year 2017. One thing that I wasn't aware of, and he mentioned, is that there is now an online portal to the commission, so you can complain online. And so he thought perhaps that the ease, making it's a little bit easier to file a complaint. It was an election year, but he wasn't sure why. But there were a significant increase in complaints. He also discussed that they're going paperless, and they've had about 25% turnover, but so that's been some of their challenges in terms of their work. The second thing we talked about was the Judicial Centers for Excellence. I won't spend too much time talking about that since that's the next item, but Scott Griffith has done an excellent job. We've reviewed that and brought that over to the full Judicial Council today for consideration as an action item. The third area is doing a survey, and David and Megan provide us an update on that. The committee has reviewed and updated and talked about appropriate questions. We were all set. I think Texas Tech was going to do it for free, do it for us, and that fell through. So my understanding, David can correct me if I'm incorrect, is we're now in the process of developing an RFP for a survey. Our understanding from the National Center for State Courts is they do telephone surveys. They're able to turn that around fairly quickly. So our goal is to get the survey done in March and get the results in April and be able to bring that to council. Is that correct? So that's where we are with the survey. The final thing, I think we did, this may have been when Eric Vinson was talking about, but we, given the times, there was some discussion about sexual harassment in terms of complaints, training for judges, and so that was a little bit that we talked about, but again, nothing yet out of the committee on that area. And that's it.
Questions of Judge Blaine?
Judge Blaine, I have a question. Is there any consideration that survey could be done by an information technology group of students, like from a university?
I know the Texas Tech fell through, I don't know, are you
Because
aware,
I
David?
do
of a-
have a group that I could maybe connect with you, and you can see if they, meet your specifications before we do the RFP.
I'm happy to visit with whoever you have, so maybe we can chat.
That'd be great.
One other matter I wish you would look at, Judge, is in December of 16, the Supreme Court and the Court of Criminal Appeals, we didn't sign an order, but we sat in the same room, I had a meeting in Dallas that we called Beyond the Bench. It was we called it a summit. And we invited every group we could think of. We invited community groups on every side of the political spectrum there is. We invited prosecutors, defense lawyers, judges, appellate judges, trial judges. I think we had about 30 judges there. We had about 200 plus there altogether. To try to discuss what was then a very difficult issue of trust in the justice system that had risen because of the friction between law enforcement and communities. And so we were trying to air those issues in presentations that took all day. And the response to it was very positive, and people felt like that a lot of understanding was reached in the interactions and the discussions. I can't begin to say that we solved the problem, but it was a very positive outcome. And I wonder if we shouldn't do that again. It doesn't have to be that format, but other states are trying to do this in different ways, but have sort of meetings, conferences, summits, something that engages people about the operation and the accessibility of the justice system, and listens to complaints about whatever it may be, and then tries to respond to it. Speaking for the Supreme Court, it was too much work, and we don't want to do it again. We'd be happy to help somebody else do it, but it was a big undertaking, and we're glad we did it. But going forward, we need some more help, and so I hope the State Bar will take a look at it and see what they think too. But I'm sure we could find lots of support for that kind of approach. And maybe get some good results from it.
I'm sure, like UT Law School, I know they've had some stakeholders, I'm sure they would be interested perhaps in being involved in something like that as well.
Okay. That's the committee reports. And it takes us to the two items of new business. The first is approval of the Centers of Excellence program.
Thanks, Chief. I'll be referring to the several pages in this document that was provided along with the agenda. Much of this will be familiar to you all. What we're looking to do here is I'll briefly report out to you what we've been doing over the last several months, and we're hoping to get the council to act on the proposal that's been revised since the last time you heard about it. When Chief Justice Hecht created and charged the Public Trust and Confidence Committee back in June, the decision was made then to place the Centers of Excellence project under the authority or under the umbrella of the committee, which has been very helpful. It's allowed us to interact with the committee in a smaller, focused setting, and I think both our concept and our plans for implementation have benefited greatly from the feedback that we've gotten from committee members. Just as a reminder, the idea here to have a Centers of Excellence project is one that that OCA staff hit on a couple of years ago when we were thinking about the best way to incorporate and integrate current thinking about performance measurement and performance management in the courts in a state like ours, which is famously non-unified, and where there is so much local control and the investment in what courts need to do what they do is so heavily at the county level. Having said that, there has been abundant study over the last number of decades about what courts should be doing, not necessarily how they should be doing it, but what matters with regard to how courts operate. And even though in a state like ours, where we've got so many judges and so many counties, it makes it difficult. There's a little argument that the concepts around the need to measure what we do in the courts and manage to understood and well-established benchmarks is something that really ought to be done. On the second page of your handout, this is not new information, but I just will point out that over the last 1.5 or 2 years that we've been working on this concept, what we've done is settled on the idea that what we'd like to do is incentivize courts to improve their performance in 4 areas. And that's in the area of governance, in the area of data-driven case flow management, in the area of access and fairness, and in the area of operations. And of course, members will remember that we've been working with several pilot sites for the last 1.5 years to get their input and to test out the tools that we've been developing. It was over a year ago, as we were getting to a point where I think we were feeling pretty good about the concept being to a point of refinement where we could roll it out. Senator Zaccarini and others on the council expressed some concern about the potential for the council to recognize a jurisdiction as being a center of excellence because they've proven to, they've shown us and provided evidence to us that they're a model in terms of their governance or the case law management principles that they're using, but they're out of compliance with some statutorily required reporting requirement or some other requirement that they operate either in the law or in rule. So we had to revisit that, and with some real hard, I think, and clear thinking about it and lots of good input from the committee, what we did is we identified several compliance standard areas separate from these performance areas, these 4 performance areas, which the council has seen and has given us feedback on over the last couple of years. But we've settled on a series of compliance standards, and those are in your document here. And what we decided to focus on was making sure a jurisdiction that wanted to participate in the program was up to date with all of its required reporting requirements, whether those are in rule or statute, whether a jurisdiction is in compliance with the requirement in law to submit court security incidents, whether all applicable TIDC requirements are being followed by a jurisdiction, whether all collections-related rules are being complied with, whether guardianship and appointment requirements in law are being complied with. And then we understood that there was a need to have a catch-all and to try to figure out a way to document and to have some confidence that a jurisdiction that wanted to participate in the program was complying with all applicable U.S. and state constitutional provisions and the statutory provisions relating to the administration of justice. So staff and the committee played around with some language. I think we started off with something that was probably too broad, but we've settled on something which is which is in your materials. It's just the statement of compliance that we would ask a jurisdiction, the judge in a jurisdiction, to sign off on as a condition of being considered as a center of excellence. And for those of you who don't have it up in front of you, it reads, I certify that to the best of my knowledge, my court is making reasonable and good faith efforts to operate in a manner consistent with applicable local, state, and federal authority relating to court administration. As I said, the language here has been, we've tried out a couple of different versions, and we've settled on something that we think will not be a disincentive to a jurisdiction to participating, but does get at what I think all members of the Public Trust and Competence Committee agree is something that's important to just have on the record. And then if you look again at the first page, we have had to make some amendments to the process that we're using. This project rolls out in phases to integrate the compliance features in addition to the performance features, but the basic concept remains the same. This is a voluntary program. Any jurisdiction at any level of our trial courts, at least at this point in the development of the project, is eligible to participate. They do a self-assessment, a readiness assessment, and then they do another self-assessment in the area of these 4 areas that we talked about, and OCA will do an assessment of their compliance with these requirements. It's possible that there will be jurisdictions that are able to check off that they're doing everything that's required, and the turnaround time would be pretty quickly, and staff would come to the council and make a recommendation that a jurisdiction be recognized. What we assume, however, is that jurisdictions that want to participate will go through these self-assessments and find that there are areas where they're lacking or deficient with regard to the benchmarks that we've set out. We'll work with them. Research and Court Services Division staff will work with them to develop an action plan, monitor their compliance, and once they get to a point where we believe they're ready, we'll make the recommendation to the council that they be recognized as a center of excellence. That area of compliance was a really big one that we got a lot of feedback about and that we've worked hard on, but there were 2 other areas very quickly, excuse me, that the committee wanted us to consider. One was making sure there was a way to ensure or at least promote ongoing improvements by these jurisdictions. And so what we've done is put a limit on the duration for which a Center of Excellence designation by the council would last, which would be 2 years. After that, the jurisdiction would have to resubmit and go through the process again. And then the other one was in the area of technology, making sure that we're looking for all available opportunities, setting the bar pretty high in the area of technology, but not so high that a jurisdiction that may be doing great work in every other area but can't afford expensive technology investments. So we've integrated some technology references into the performance areas. At this point, I think I speak for the committee, Judge Spillane, and that members are satisfied with the changes we've made and that we've been responsive to their suggestions and their concerns and requests. And we'd love the council to consider approving this for rollout.
Questions of Scott or Judge Spillane? Program comes from the committee with the recommendation that we adopt it, so we'll take that as a motion.
Second.
Any further discussion? All in favor?
Aye.
Opposed? Passes. The program's approved. Thanks for all your hard work on this. I know it's been a lot of hours, and I hope expect it will bear fruit. The last action item that we have on the agenda is amendment to the Collections Improvement Program members. Present that.
Thank you, Chief. I would just like to brief you real quickly and hopefully get you out exactly by noon on the proposed amendments to the Collection Improvement Program rules. You were provided a memo with the attached rule with the agenda and meeting materials. I'll be referring to that. So the recommendation is being made by the Research and Court Services Division of the Office of Court Administration. This is in response to the Data Committee of the Judicial Council's instruction to OCA to go back and look at all of the reporting requirements that are reports that are being submitted to OCA to determine whether they're being fully utilized, whether they're essential, and also to make sure that there isn't a duplication of efforts, that entities, local, other governmental entities aren't already reporting this information to another state entity. So if you can look at your the rule that's in the packet, I've highlighted the provision that the Research and Court Services Division recommends we repeal. It's basically in 175.4C1. It is the annual reporting requirements. If you will look at them, numbers or letters A through E are information that's specific to local collection improvement programs, operations, salaries, fringe benefits, what other things they're doing. And these items are not really essential or required under the collection improvement statute. So OCA does not think these are necessary. Subsection F is a little different. This calls for information regarding local and contract jail statistics and an average cost per day to house a defendant. And the problem with this reporting element is jail facilities are not under the authority of the local collection and improvement program, so it's not really information they have that's readily available to them. So it results in incomplete reporting or no reporting. And then in the instance of county jails, this information is already being reported by the county jail facilities to the Commission on State Jail Standards. I believe that's what it's called. So we don't believe that we need to be collecting that information as well. And then letter G is a compilation of 12 months of the monthly reporting requirements that are listed in subsection 2. This leads me to the next recommendation. Right now, we have a list of items that are actually pertinent to the work of the Collections Improvement Program. Has to do with their cases, the fees and fines assessed, what's collected, the average rate to disposition, etc. That information is important, and we recommend or request that they report that monthly, but they're only required to actually submit it annually if they haven't done it monthly. So the hope is we repeal all this unnecessary annual reporting, and then they can focus on the monthly reporting that we really need. I think that's it. Did I cover it? Okay.
Questions, Amina? So is there a motion to amend the CIP rules and publish the amendments in the Texas Register?
So moved.
Second?
Second.
Any further discussion? All in favor?
Aye.
Opposed? It carries. That completes the agenda. Let's see, the next meeting is on June 29th. So you'll remember our discussions that we are moving up a little bit the timetable that we followed in the past so that we can have our legislative proposals more firmly in line earlier in the process, and then begin the drafting of the legislation and working with our legislative members to find sponsors and be better prepared for the beginning of the session. So the June meeting will be bigger than it has been in the past because we'll be trying to get all of that together. So we may not be able to finish by then. Anything else for the good of the order?
Good job, Chief. It's 11:59.
All right. We can visit for about 30 seconds and then we're adjourned.